This vlog includes general information and is intended to be used for informational purposes only. These informational materials should not be taken as legal advice and do not create an attorney-client relationship. The outcome of any particular matter will depend on a variety of factors. For specific legal problems, you will need to contact an attorney. How does an employee request a reasonable accommodation from their employer?
When an employee decides to request an accommodation based on a disability, the employee or their representative must let the employer know that they need an adjustment or change at work to be able to perform the essential functions of their job, and that the need for the accommodation is related to a medical condition. To request an accommodation, an employee may use plain English and need not mention the ADA or use the phrase reasonable accommodation. There must be a connection between the disability and the accommodation requested. It is best, but not required, to put a request for a reasonable accommodation in writing. And to keep copies of all documents or notes of conversations related to the request. A family member, friend, health professional, or other representative may request a reasonable accommodation on behalf of an individual with a disability. The following are examples of requests for reasonable accommodation. 1. An employer tells their supervisor, "I'm having trouble getting to work at my scheduled starting time because of medical treatments I'm undergoing." Two, an employee tells their supervisor, "I need 6 weeks off to get treatment for a chronic back problem." 3. A new employee who uses a wheelchair informs their employer that their wheelchair cannot fit under the desk in their office. 4. An employee's spouse phones their supervisor to inform them that the employee had a medical emergency due to multiple sclerosis. Needed to be hospitalized, and thus requires time off. 5. An employee has been out of work for 6 months with a work-related injury. The employee's doctor sends the employer a letter. Stating that the employee is released to return to work, but with certain work restrictions. Alternatively, the letter may state that the employee is released to return to a light-duty position. The following is not an example of a request for a reasonable accommodation. An employee tells their supervisor that they would like a new chair because their chair is uncomfortable. Although this is a request for a change at work, the statement is insufficient to put the employer on notice that the employee is requesting a reasonable accommodation. The employee did not link their need for the new chair with a medical condition or disability.
What documentation may an employer request in response to the employee's reasonable accommodation request?
The employer may ask for supporting and reasonable documentation about the employee's disability and functional limitations to the extent that they are related to the accommodation request if the disability or the need for accommodation is not obvious. Reasonable documentation means that the employer may require only the documentation that is needed to establish that a person has an ADA disability. And that there is a connection between the disability and the reasonable accommodation requested. This documentation may be referred to as medical support and generally comes from an appropriate healthcare professional who is treating the employee. Including doctors, including psychiatrists, psychologists, nurses, physical therapists, occupational therapists, speech therapists, vocational rehabilitation specialists, and licensed mental health professionals. In requesting documentation, employers should specify what types of information they are seeking regarding the individual's disability, its functional limitations, and the need for reasonable accommodation. As an alternative to requesting documentation, an employer may simply discuss with the person the nature of their disability and their functional limitations. The employer should explain to the employee why it is requesting information, such as to verify the existence of an ADA disability or to support the need for a reasonable accommodation. The employee may be asked to sign a limited release allowing the employer to submit a list of specific questions to the healthcare or vocational professional. Note: if an employee's disability or their need for reasonable accommodation is not obvious, and they refuse to provide the reasonable documentation requested by the employer, then the employee is not entitled to reasonable accommodation.
What limits are there on documentation requests by employers in response to an employee's reasonable accommodation request?
In response to a request for reasonable accommodation, an employer may not ask for documentation that is unrelated to determining the existence of a disability and/or the necessity for an accommodation. In most cases, this means an employer cannot request a person's complete medical records, because they are likely to contain information unrelated to the disability at issue. And the need for accommodation. If an employee has more than one disability, an employer may request information pertaining only to the disability that relates to the reasonable accommodation request. The following are examples of the scope of documentation that an employer may request in response to an employee's request for reasonable accommodation. 1. An employee says to their employer, "I'm having trouble reaching tools because of my shoulder injury." The employer may ask the employee for documentation describing the impairment. The nature, severity, and duration of the impairment. The activity or activities that the impairment limits. And the extent to which the impairment limits the employee's ability to perform the activity or activities. i.e., the employer is seeking information as to whether the employee has an ADA disability. Two, the employee tells their supervisor about their disability. And requests a laptop computer to use in meetings. Since neither the disability nor the need for accommodation are obvious, the supervisor may ask the employee for reasonable documentation about their impairment. The nature, severity, and duration of the impairment. The activity or activities that the impairment limits. And the extent to which the impairment limits the employee's ability to perform the activity or activities. The employer may also ask why the disability necessitates use of a laptop computer, or any other type of reasonable accommodation, such as a tape recorder, to help the employee retain the information from the meetings. Three, an employee's spouse phones the employee's supervisor on Monday morning to inform them that the employee had a medical emergency due to multiple sclerosis needed to be hospitalized, and thus requires time off. The supervisor can ask the spouse to send in documentation from the employee's treating physician that confirms that the hospitalization was related to the multiple sclerosis and provides a reasonable estimate of how long an absence may be required from work.
Does an employer have to provide the exact accommodation that an employee has requested? No.
Employers are only required to provide an effective accommodation, which means one that enables the employee to perform the essential functions of the job. It does not have to be the exact accommodation that the employee requested, nor the employee's preferred accommodation. An effective accommodation removes a workplace barrier, thereby providing the employee with an equal opportunity to apply for a position, to perform the essential functions of a position, or to gain equal access to a benefit or privilege of employment. If there are two possible reasonable accommodations, and one costs more or is more burdensome than the other, the employer may choose the less expensive or burdensome accommodation as long as it is effective. Similarly, if there are two or more effective accommodations, the employer may choose the one that is easier to provide. In either situation, the employer does not have to show that it is an undue hardship to provide the more expensive or more difficult accommodation.
Employers and employees are expected to engage in an interactive process to determine an effective accommodation.
Courts have ruled in favor of employers in failure to provide reasonable accommodation cases where the employee was responsible for the breakdown in the interactive process. Work with your employer during the interactive process to find an accommodation that works for both you and the employer. Don't quickly reject a suggestion from your employer for a different type of accommodation than you asked for. Give serious thought to whether or not it will be effective. If you can, try it out first. If it's not working, go back to your employer and reopen the interactive process. Employers do not have to lower production standards or ignore poor quality work as a reasonable accommodation. Employers also do not need to remove essential functions of a person's job. Note: following your accommodation request, it is important to document your cooperation with your employer during the interactive process.
What is a reasonable time frame for an employer to respond to the employee's request for reasonable accommodation?
The employer should act promptly to provide the reasonable accommodation. If the employer and the employee with a disability need to engage in an interactive process, then it should proceed as quickly as possible. Unnecessary delays can result in a violation of the ADA. However, there are no strict timelines in the ADA. The relevant factors in determining whether there has been an unnecessary delay in responding to a request for reasonable accommodation include the reason or reasons for the delay, the length of the delay, to what extent the employee with a disability and the employer each contributed to the delay, what the employer was doing during the delay, and whether the required accommodation was simple or complex to provide. The following are examples of whether the employer reacted with unnecessary delay to accommodate a request. 1. An employee who is blind requests adaptive equipment for their computer as a reasonable accommodation. The employer must order this equipment and is informed that it will take 3 months to receive delivery. No other company sells the adaptive equipment the employee needs. The employer notifies the employee of the results of its investigation and that it has ordered the equipment. Although it will take 3 months to receive the equipment, the employer has moved as quickly as it can to obtain it. And thus, there is no ADA violation resulting from the delay. The employer and the employee should determine what can be done so that the employee can perform their job as effectively as possible while waiting for the equipment. 2. An employer provides parking for all employees. An employee who uses a wheelchair requests from their supervisor an accessible parking space, explaining that the spaces are so narrow that there is insufficient room for their van to extend the ramp that allows them to get in and out. The supervisor does not act on the request and does not move it forward to someone with the authority to respond. The employee makes a second request to the supervisor. Yet, 2 months after the initial request, nothing has been done. Although the supervisor never definitively denies the request, the lack of action under these circumstances amounts to a denial. And thus violates the ADA.